My name's James Ballantyne and I'm the principal of Ballantyne Law Group. One of the most common issues confronting both businesses and property investors during this pandemic is how commercial tenancy should be dealt with. We've put together this video to provide a brief overview of the Code of Conduct for Commercial Leases, which was one of the measures announced by National Cabinet in the last few weeks. The overview is not intended to be an exhaustive examination of the area, and that's impossible at this stage, and we're still waiting for the release of specific regulations implementing the Code's measures. So the Code was announced by National Cabinet on 7 April 2020 as part of a range of measures. For those who aren't aware, the National Cabinet's made up of the Prime Minister and each state and territory leader, and while in and of itself it doesn't have legal authority, the decisions it made needs to be implemented at the relevant government level, a little bit like international treaties needing to be ratified in each country to have any effect. So as property and leasing matters are state-based, this means it's up to each state to regulate the code as part of its own state program. In Queensland, that process started with the passing of the COVID-19 Emergency Response Act on the 23rd of April. So that act included a number of mechanisms for implementing the code through regulations under this act and under the Retail Shop Leases Act. The regulations can include things such as the prohibition on recovering possession or terminating leases. The Act also introduced the role of the Small Business Commissioner, who will be tasked with a number of functions, including assisting in the resolution of small business leasing disputes and administering mediation processes in relation to the same. At this stage, none of those regulations have actually been released, so we'll look further at the code to see what the regulations are likely to include. So obviously the code relates to commercial tenancies only, retail, commercial, office, industrial. There's separate rules that have been announced relating to residential tenancies, and we'll cover those in a separate presentation. So the code states that it's intended to be mandatory for what are called SME tenants, small to medium enterprise tenants. Those are tenants who are eligible for the JobKeeper program, where their business has faced a 30% fall in turnover, and that have a turnover of up to $50 million. So that turnover limit is intended to apply at individual franchisee level for franchises, so they take each individual franchise's turnover rather than the entire franchise group, but at the group level for corporate groups. So while the code's not mandatory for leases to which it doesn't apply, the code does state that it should nevertheless apply in spirit to all leasing arrangements for affected businesses having regard to the size and financial structure of the business. It obviously remains to be seen how many landlords will take notice of that exhortation. So the stated objective of the code is to share in a proportionate, measured manner the financial risk and cash flow impact during the COVID-19 period, whilst seeking to appropriately balance the interests of tenants and landlords. The code includes a number of overarching principles intended to apply. I won't go through all of them, but I'll touch on some of the key ones. Tenants and landlords are required to negotiate in good faith. Tenants and landlords must act in an open, honest and transparent manner, with each providing sufficient and accurate information within the context of negotiations to achieve outcomes consistent with the code. Leases have to be dealt with on a case-by-case basis. There won't be a one-size-fits-all industry-wide approach. So in addition to the overarching principles, the code sets out a number of leasing principles that should be applied as soon as practicable on a case-by-case basis. Again, I won't touch on all of them, but I'll touch on the key ones. So non-termination of leases for non-payment of rent during the pandemic period and a reasonable recovery period. It's important to note that this suggests that landlords are not prohibited from terminating leases for other breaches. Tenants have to remain committed to the terms of their lease, of course subject to any agreements or amendments negotiated under the code, and a failure to do so by a tenant would forfeit any protections, such as the prohibition on termination, that is provided under the code. So landlords have to offer proportionate reductions in rent in the form of waivers, which is where the rent's that's reduced doesn't ever have to be repaid, or deferrals, which is where the rent reduced is deferred to a later time. And those reductions have to be based on the reduction of the tenant's trade during the pandemic period and subsequent reasonable recovery period. Now, of those reductions, waivers must be no less than 50% of the total reduction in rent and should be a greater proportion where the failure to do so would compromise a tenant's ability to fulfil their ongoing obligations under the lease agreement. Landlords can't charge any fees, interests or other charges for waivers. Deferrals have to be amortised over the balance of the lease term or for 24 months, whichever is the greatest, unless the tenant agrees otherwise. Landlords can't charge punitive interest on any deferrals. If a landlord receives a reduction in outgoings, and there's been some concessions and other issues given in relation to land tax rates and insurance and so on, those reductions have to be passed on proportionately to the tenant. And landlords also should share the benefit of loan payment deferrals that they receive from their lenders. During the pandemic period and a reasonable recovery period, landlords cannot draw on any security provided by the tenant, and there can't be any rent increases other than increases based on turnover rent. I think one of the most important issues that will need to be addressed by the regulation is how the pandemic period and the reasonable recovery period are actually determined. From midnight tonight, which is the 15th of May, we're starting stage 1 of Queensland's roadmap to easing restrictions. Stage 2 is intended to start on 12 June and stage 3 on 10 July. Now, obviously, many businesses will be under significant restriction to their ordinary trade during this period and even after stage 3 for some of them. So it's not clear whether the pandemic period covers these stages or we're already into the recovery period. There's been some fairly pessimistic views on economic recovery, and it remains to be seen whether the reasonable recovery period is going to be linked to economic recovery or something else. So where landlords and tenants can't reach an agreement, then the code covers mandatory dispute resolution, a mandatory mediation process. So in Queensland, the Retail Shop Leases Act already has a framework for dispute resolution for retail leases, but with the establishment of the Small Business Commissioner, it remains to be seen how the process is going to work for commercial leases generally, and particularly those that aren't retail shop leases or caught under that framework. So while we're waiting for further clarity about how this code is going to be implemented in Queensland, we're strongly encouraging our landlord and tenant clients to start negotiating under the code, put in place practical, workable solutions. In our view, it's important that these agreements are appropriately documented and able to be reviewed in the events that conditions or regulations change. So the code has potential to require complex commercial arrangements to be put in place for the period, and if you're a tenant or a landlord, you should obtain appropriate legal advice about your rights and obligations. Our property team's available for discussion and consultation. You can call us on 56067332 or follow our website at www.ballantinelaw.com, where you can book a video conference with one of our team. Thanks for listening.